sentencing grids. And as we hear some laws that have to do with that criminal laws, then I think it's very helpful for us to understand about the sentencing grid, which Kansas has, and we'll talk more about it. They're really helpful as we start talking about what levels of infractions and offenses we have. So thank you to the Sentencing Commission for those. Okay, committee, we're going to go ahead. We're going to have a hearing on 3 bills, and then we're going to we're going to work 2 bills. So we're going to get going. We're going to, I'm going to limit questions to 1 question. And so be careful with your question. If we have time, I kind of have time left. I mean, I have time slots for what I think, how long each bill and working the bill should take. And if we have time, I will be happy to offer more time for questions. But at the moment, this is what we're going to need to do. So I will open the hearing on House Bill 2212 and ask Jason Thompson, the reviser, for a bill brief. Thank you.
Thank you, Madam Chair. As you said, Jason Thompson, Office of Reviser of Statutes. You should have the bill brief in your packet. House Bill 2212 increases the reimbursement amount of money that the Secretary of Corrections is allowed to make to inmates for losses of their losses of personal injury or property damage or loss caused by negligence. It also requires notice to the Secretary for claims exceeding the reimbursement maximum. The statute you're amending in this bill is KSA 46-920 that authorizes the Secretary of Corrections to reimburse inmates for certain injury or damage awards. The limit provided in current law is $500. You can see that on line 16 of the bill. And then the bill amends that number to $750. And then right after that, the bill also provides that an inmate must give notice to the Secretary of the nature, time, date, and place for claims that exceed that amount. But failure to do that will not prevent the claim from going to the Joint Committee on Claims against the state. So it's not a procedural violation, essentially, that prohibits your claim later. It's just something that they're supposed to do. I would note that claims exceeding the $750 amount, and I'm pretty sure the chairperson can get into this as the chair of that joint committee that I just mentioned, those are submitted to the Joint Committee on Special Claims against the state. So right now, if it's over $500, it goes to that committee. The Secretary can approve it if it's under 500. And that would be the same going forward, except the number would be 750. So that's essentially what the bill is dealing with. Happy to answer questions.
Committee, do you have questions for the reviser? Okay, thank you. Okay, committee, I'm the only proponent here, so I'm just going to talk you through a little bit why we have this, and then please ask questions. The Special Claims Against the State meets 3 or 4 times every year to hear claims from folks who think that they have a claim that the state needs to pay. It's kind of the last resort, and about 85% of the claims come from residents in our state penitentiaries. And so what happens is we get the inmate on the phone and they tell us what their claim is, and there's 7 people, House and Senate members, on the phone, and we ask them questions. We hear the Department of Corrections, what their view of the situation is, and then we decide if we'll pay that claim or not. And we have heard claims that go from $2.50, like a magazine subscription of the TV Guide, up to claims for injuries up to $1.5 million. So it's a wide variety. And so what we have found was happening, 2 things. One, the $500 had not been changed for many years. And so it was time to just make that change. And the committee voted, and the committee talked about what we needed to do. It's not a committee that in and of itself can hear bills and pass bills to be heard by the full House. And so it was a recommendation of the committee to up that to $750. That other piece about that they need to give notice to the Secretary, what happens with that is if what we were finding was if someone had something that was over $500, let's say it was $550, they would bring it to the committee, and the Department of Corrections, their answer would be, they did not go through the proper channels, and so you have to deny this claim without prejudice. And so then we'd have to send it back. And so it was kind of a time thing. So we put this other section in here that they have to provide notice. So now, once they do that, just give notice, then they can go straight to the special claims against the state. And we won't deny them just because they didn't follow the procedure, if that all makes sense. So I will take questions from anybody. Representative Schreiber.
Thank you, Madam Chair. Just curious, are there a lot of requests that would fit into this $750 and below, or is it?
Yeah, that's a
few?
great question. I said we meet 3 or 4 times every year, and I'd say we have about 20 to 30 claims each day, and probably a third of them would be over the 5. Those are all just kind of approximations, but probably a third of them would be over 500. Yeah. Yep. Representative Carmichael.
Thank you, Madam Chair. Excuse me. How many of them would have been over $750? How many people are we leaving out by this bill?
So we're not leaving out anyone by this bill. What we're doing is, if it's between before, if it was $500, they had to go straight to the special claims committee. Now, if it's over $750, they go straight to the special claims committee. If it's between 0 and $750, they go through the Secretary of Corrections now. First, they have to make their claim first through the Department of Corrections. If it's over $750, they can come straight to the special claims against the state. Does that make sense? Okay. I'm happy to answer anyone else's. Does anyone else have another question? Yeah. Representative Bohai.
They still need to send notice to the secretary of the claim that's over 750, but they get to go straight to you. They just have to let the secretary know.
Yes, exactly.
Thank you.
Because what was happening before was, if they didn't give notice to the secretary, when we had the hearing, they would just say, well, they didn't follow the procedure because they didn't let us know. So we're just asking them to let them know so that then we can actually pay or not pay the claim instead of just having it go back because of the procedure. Any other questions? Okay, are there any opponents, neutral testimony on this? Okay, then I will close the hearing on House Bill 2212. And I will open the hearing on House Bill 2349. And we will hear from the reviser, Jason Thompson, a bill brief on this one.
Thank you again, Madam Chair. Jason Thompson, Revisor's Office again. So switching gears now to House Bill 2349, which authorizes law enforcement officers to do investigations under the Scrap Metal Theft Reduction Act, also creates some criminal penalties for certain violations of that act, and permits municipalities to enact or enforce ordinances, resolutions, and regulations relating to scrap metal that are not in conflict with the act. The couple sections to this bill, Section 1, KSA 50-6,109A, that's the statute that gives the Attorney General jurisdiction and authority over all matters involving the Scrap Metal Theft Reduction Act. The bill continues that authority for the Attorney General, but adds a couple provisions near the bottom of page 1 that allow Kansas law enforcement officers to conduct investigations of violations of the Scrap Metal Act, and upon conclusion of an investigation, submit their investigative reports to the Attorney General, regardless of whether local action is taken as a result of the investigation. In addition, local enforcement actions for violations of the Scrap Metal Act are reported to the Attorney General. So they still have all of the authority and administration that they do have now, just some additional powers for the local law enforcement and officials as well. Section 2 then is KSA 50-6,109C. That's the statute that authorizes a civil penalty to be imposed on scrap metal dealers who violate the Scrap Metal Theft Reduction Act. The bill adds a new subsection D, which is near the bottom of page 3. These are criminal penalties for knowingly committing violations of certain provisions of the Scrap Metal Act. They're kind of enumerated there: avoiding the reporting requirements, using a false description of the items sold or purchased, concealing a true identity of the seller, accepting items a scrap metal dealer is prohibited from accepting. So those are the kinds of violations that will subject you to a criminal penalty, which is a Class B let's see, I'm reading my note. Class B non-person misdemeanor on a first occurrence, and a Class A non-person misdemeanor on a second or subsequent occurrence. The bill also adds a subsection E, which is on the final page of the bill, which has to do with violations of the scrap metal registration dealers. That's purchasing while their registration is suspended or revoked, or committing 2 or more violations of purchasing scrap metal without being registered as required by law. Those violations would be a Class A non-person misdemeanor. I note in the brief that the references in the bill on page 4, there's 3 of them to 50-6,112. There should be an A at the end of that. 6,112 was repealed. There's now like an A, B, C, D. It should have been A. So there'll be a technical amendment on that issue, but the bill brief is right. There's an A. And then finally, section 3 is KSA 50-6,109F. This one I know is of particular importance to at least one member on this committee because we've talked about it many times over the years. This provision that was enacted when the Scrap Metal Theft Act was passed by the legislature prohibited municipalities from enacting or enforcing ordinances, resolutions, or regulations relating to scrap metal, and essentially repealed all of the current ones in existence at that time. The amendment here would allow municipalities to enact those ordinances again after July 1st of 2025 if the enactments are not in conflict with this act, and any criminal or civil penalties for violation of that enactment is the same as the penalties under the state Scrap Metal Act. So essentially giving some local authority back that was taken away several years ago. It would take effect on July 1st of this year if adopted, and I'll be happy to answer questions.
Okay, thank you. Committee, what questions you have for the reviser? Representative Curtis.
Thank you, Madam Chair. I just want to make sure I heard correctly. We are restoring some local control for the matters of scrap metal. This has been like a 12-year project for me, because I just have to share with you, KCK had actually been on a really good path to deal with what was a huge issue in our community with scrap metal, and we just zapped that away from them. And as a result, we actually caused many small scrap metal dealers to go out of business because of the onerous provisions that we placed on them. So now we have today fewer scrap metal dealers across our state, especially small scrap metal dealers. So I just want to make sure we now can have some local control on this issue again. I think that train may have left the station for my county, however, but confirm?
Madam Chair, Representative, you are certainly the first person I thought of when I wrote that language. Yes, Madam Chair, the provision here undoes the prohibition, right? So under the current law, you're not allowed to enact a local ordinance that deals with the topics in the Scrap Metal Theft Reduction Act. They're reserved exclusively to the state. And the amendment would allow ordinances to be enacted again after July 1st of 2025, as long as they don't conflict with the act and as long as they have the same penalties as the act. So if you could get your county to enact one, you could try again, yeah.
Committee, any other questions for the reviser? Okay, thank you, Jason. All right, I will go ahead and call up Craig Seepich from the National Insurance Crime Bureau. Is Craig here? Not on, is he on WebEx? Nope, okay. Okay. We will wait, we'll call him back and see if he can come back in a minute, or if he shows up. So I'll go ahead and have Ed Klump come up with, as you know, the sheriffs, chiefs of police, and the peace officers. Welcome to committee.
Hey, Chair Humphreys, committee members, I'm Ed Klump with the three associations the chair mentioned, save my breath. This bill is about not just giving local control back. It's really about being able to enforce the act as it exists by giving us some limited authority back at the local level. So let me explain. And maybe I should start with a little bit of history here. The reason that it was requested to have a statewide scrap metal law is because when our communities had scrap metal laws, they were different everywhere. We had some scrap metal dealers who had to register in multiple places. And they also, we had problems with people simply not taking their stuff that we were looking for into these scrap metal dealers. They would go to a jurisdiction that didn't have a law. And so the industry was looking for consistency. We were looking for consistency. And that's how it came to be state law. So the reason we're here today, and I want to make clear, this is not our bill. This bill was generated from Wichita PD. I always feel awkward when I talk before the people that introduced the bill, but here I am, that's fine. But the problem is, if you look on page 1, lines 12 through 14, and then jump down to 20 in that list below that, we are forbidden to investigate violations of the act. It gives exclusive authority to the Attorney General for that whole list of certain things, not everything, but certain things. And then there's a process when we investigate and we find administrative violations, we report that back to the Alcohol Beverage Control, and then they deal with the administrative violations. So that's kind of what I think the aim is here, to do that with this bill. So this bill would allow local law enforcement to investigate violations, which is very appropriate for numerous reasons. One, we know the Attorney General's office is short on investigators and staff right now, but we are the ones that identify it in the first place. And we are the ones investigating crimes in our communities that go to the scrap metal dealers and we find certain violations. And I got to tell you, most scrap metal dealers in the state of Kansas are very honorable people doing the right thing. But we have that handful, and we always will have. And that's what we're trying to address with this. I'll also point out that the creation of a few misdemeanors in here that before there weren't any misdemeanors in this, and they're A and B misdemeanors, only apply to 3 statutes in the act. So any violation outside of those 3 statutes is still an administrative violation, and the AG can enforce those. So those are 50-6, COM 110, 111, and 112. Those are the statutes that deal with items that cannot be received from an individual, barring their proof that they come by it legally. And the requirements for registering who brings certain items in and then recording those transactions. So what we're really going after here, and I'll let Wichita explain this in more detail, but what we're really going after here is the bad actors that are intentionally just taking stuff in, they shouldn't be taken, then just not recording it and hoping we don't find it. And like I say, we don't have a lot of dealers that do that, but that's where a lot of our stolen stuff goes, to the ones that are. So to me, it's pretty straightforward. I always hesitate to say that in this building, but that's the essence behind what we're trying to accomplish. And Representative Curtis, you talked about Kansas City, and Topeka, several locals had ordinances and procedures and stuff, which this act did away with. And this is kind of a attempt to maybe step back, but not all the way, keep the consistency across the state of the regulations, but at the same time, allow us to do what we do best at the local level, investigate, handle small things at the local level, handle the administrative things at the state level, very much like ABC and Silvermont Beverage. And I'll stand for questions.
Okay, thank you. I think we'll wait. We'll hear the other proponent and then do questions. Okay, I think we have Trevor Macy from the Wichita Police Department on WebEx. Trevor, are you there?
I am. Can you hear me?
Okay. We can hear you. We can't see you yet. There you are. Okay. Yes. So Trevor, welcome to committee, and we appreciate your testimony. Go ahead.
Well, thank you, Madam Chair and members of the committee. I'm Trevor Macy. I'm a detective with the Wichita Police Department. Currently work in the larceny section, and I'm here to speak on House Bill 2349. So to give you an idea of kind of the scope of what we're dealing with in Wichita, last year we had a little over 16,000 larceny cases in the city, and that's pretty typical for us for a given year. In a lot of those cases, we're seeing thefts of large amounts of various metals that are being taken, whether that's copper pipes, copper wiring, catalytic converters, stolen vehicles. In fact, I was looking this morning, and within 1 week, we had more than $100,000 worth of metals stolen from a vacant building in a Wichita neighborhood. So that's just one building in one neighborhood. So you can imagine kind of the scope of it when we expand to the wider city. But we know that these types of crimes are happening, and as we're investigating them, we know that a lot of these metals that are being stolen are being taken to scrap yards and being sold by people. And in 2015, we had the Scrap Metal Theft Reduction Act, which was passed, which allowed for that system to help track these scrap metal sales and reduce and deter the sale of stolen metals. And it requires, certain information be gathered about the people who are selling it. They're assigned statements saying that they're the owner of the item that they're selling. Requires titles for vehicles that they're trying to sell, and a photo of the items that they're selling and tags of the people that are there. And it's a good idea, but limited staffing at the state level kind of hinders the ability to investigate these instances. And the current rules just really make us at the local level kind of powerless to do anything about it when we find these types of crimes occurring. So this new bill would allow us to have the ability to really assist the state and supplement their efforts in investigating these types of crimes. Would allow our municipal courts to prosecute a limited number of the violations and hold offenders accountable. They're misdemeanor crimes, and they're not trying to expand the scope of the original bill in terms of what constitutes violations, but really just enhance our ability to help the state when it comes to enforcement. Because while the law in its current state is a good framework for what we want to see, I think that if we are able to partner with state law enforcement on these, the local law enforcement at the local level, we are much more familiar with these areas. We're familiar with the scrap dealers. And while a lot of them and most of them are doing the right thing, they're getting the required information, we do have bad actors in this area who are taking in stolen goods knowingly. And the bad actors that we have are really bad. And we want to be able to have the tools necessary to help curb that and stop the sale of these stolen items.
Okay, thank you. And are you okay answering some questions if anyone has any?
Sure, I'm happy to.
Okay, thank you. Committee, now we'll do questions for either proponent. Representative Carmichael.
Thank you for giving me this opportunity to inquire, Madam Chair. Detective Macy, I'm a little concerned here because this bill's been around for 11, 12 years. And today I'm told for the first time that the Attorney General's office doesn't have the resources or the motivation to enforce provisions of this law, and that local law enforcement needs to be at least partially taking over that responsibility. Was Attorney General Schmidt doing his job, or is it just a new problem that has developed since Chris Kobach became the Attorney General?
Well, I can't speak on the efforts of, thank you for the question, Representative Carmichael. I can't speak on the efforts of current or past attorneys general, but I can say that just in our unit in larceny in Wichita, we have 4 detectives and we work 16,000 cases a year. So we are kind of at a minimum level, trying to just keep up with the number of things that are going. I'm not sure what the staffing levels are like at the Attorney General's office, but I can imagine they're probably in the same situation that we are. There's just not enough people to investigate what's going on. And so really what we want to do is just be able to supplement that with the resources that we do have, because we're already investigating these crimes. But when we get to that point, when we realize that there's a violation of the Scrap Metal Act, we're not able to take any action, and we have to kind of defer that to them and put that on their plate, when we could just take care of it on our end when we discover those violations.
Thank you, Madam Chair. I think the answer was obvious.
Are there any other questions, committee? Representative Curtis.
Thank you, Madam Chair. So either Ed or, I'm sorry, Mr. Macy, if you could, so I'm reading it real quickly, and we're focusing mostly on scrapyard dealers. Does this also, I think this doesn't, it does help our Scrap Metal Act, but is all the focus on the dealers? Will you also be investigating the actual crime itself in helping with that?
Ed, go ahead.
Thank you, Representative Curtis. And I'm sure Trevor will want to expand on my answer to this, but the 3 statutes that I listed include violations of people bringing stuff in as well. So it's not just on the dealers, it's that process and interaction between people bringing stuff in. And I can tell you from the feedback I get from our investigators across the street, yes, we are actively investigating these cases all the time. And it's, you know, like I said, it's like CMB. We're a force multiplier for the regulatory agency because we're out there every day and seeing these violations firsthand, and in a better position to investigate it actually more efficiently because we're right there at the time than having somebody come in after the fact and try to investigate it.
Okay, so I do have one other quick question, Ed, for you. So you're adding the misdemeanor. There's already a civil action and felony criminal, but you're adding the misdemeanor, or there's not any? Is it just civil so far, or? Okay, maybe that's for Jason. I don't
I
know.
let Jason answer that. I don't think
Okay.
there's a felony in here.
Okay. For any, okay. I didn't know. You're just adding the misdemeanor.
It's primarily been a civil process.
Okay. Okay, that's what I wasn't sure about. Representative Schreiber.
Thank you, Madam Chair. Mr. Klump. You should never leave.
I know.
My only question was, would it be more advantageous to have this effective on printing in the register, Kansas Register, or rather than waiting until statute book?
You know, I really hesitate to put things on the register if it's not something that really needs to be fixed right now, because what's in current law is wrong. And I don't think what's in current law is wrong here. I think we just need to make it better.
Yeah.
I think, and I'll let Trevor answer that, but we're talking maybe 2-3 months.
Right.
I don't think it's going to make that big a difference.
Okay.
Thank you for asking, though.
Trevor, did you have an opinion about that?
Yeah, we don't really have a preference because we still have to write an ordinance for our local municipality if this is put into effect. So it's going to take a little bit of time on our end as well.
Okay, thank you. Committee, do you have any other questions for the proponents? Okay, so we have written only a proponent testimony from Craig Seepich from the National Insurance Crime Bureau, and also written only from Matt Bingesser from the Office of the Attorney General. So make sure you take a look at those. That would be interesting. And then I will call on Mr. Brad Smoot. I don't know that you have testimony, but you will give us some information. Maybe it's neutral, not sure. Go ahead.
Thank you, Madam Chair, for your indulgence. I do not have written testimony yet, but I will certainly get it for you, due in part to the truncated nature of this session, why things are happening pretty fast. I represent AMR, Advantage Metals Recycling. We've been involved in the development of the statewide bill for the last decade or so been through countless meetings with any number of legislators and law enforcement. Ed and I have gotten to know each other. In fact, you ought to just sit up here and be handy in case I need you to. But we selected being neutral today for a couple of reasons. One is that we're late to the dance. I just got my marching orders on what our company position is on this at 2:30. And secondly, we think there's some things in here that are really good. And then we have some concerns over other language in the bill that changes a very complex and tightly negotiated piece of legislation that we've dealt with for many, many years. AMR has facilities in Kansas City, Kansas, Topeka, Emporia, Columbus, Fort Scott. So we're very, very supportive of law enforcement efforts to catch the bad actors. We have no trouble with law enforcement doing everything it can. If we can do something in this bill to enable them to do so, kind of like Ed's analogy to ABC, and see if there's some way that we can design something that works similarly. On the other hand, we don't want to create different laws again, county by county, city by city. The law as it reads says it can't be in conflict with the state law, or the bill as it reads says it can't be in conflict with state law. If we add a new metal to the prohibited list, is that in conflict or is that just an addition? It's that kind of question that I think we need to sit down with the City of Wichita folks, with Ed and others. And just by way of background, and Ed can certainly verify this, we had countless hours of meetings with folks, and there will be dozens and dozens and dozens of small businesses that are in the scrap metal business here at your doorstep if we engage in this and don't consult them. They have a vested interest in this, and how it reads and how it impacts them is very important. We, as a big national company, we're pretty much adapted to all the reporting requirements, the statewide database. We don't seem to have these problems. Many of these problems for the last decade have come out of Wichita. But we do support the effort to improve the marketplace, but we want to make sure we get it right. And I just want to tell you about the other people who couldn't be here today. They're going to have something to say about this. So with that, Madam Chair, I'm happy to stand for questions.
Okay, thank you for that. Representative Curtis? Yep, Representative Curtis.
Thank you, Madam Chair. So my question is, do you think, you say that there hasn't been many problems since we enacted this legislation. Do you think perhaps that is because of the lack of resources in the Attorney General's office to pursue these cases?
Well, what I meant to say was we haven't had many problems in our area with this. In fact, I'm not aware of any. But I have no idea how to answer that question. I really don't. It's kind of one of those, if it wasn't enforced, we don't know that it happened. If it wasn't discovered and investigated and reported, we wouldn't know. The state database might be able to tell you some of that, and that's why we created that system. Expensive. It was run by the KBI. I assume it still is. It's complicated. It required a lot of changes to the way all the scrap metal yards worked and operated, and their responsibilities to the state. So there's a lot invested in the system that we have. Finding ways to make enforcement better and more thorough is what I think this purpose is, and we're certainly in favor of that part. We're just concerned about damaging the underlying bill and underlying current law.
Okay, thank you. For me? Yep. Mm-hmm.
Madam Chair, could we get a report on how many cases the AG has had and how many they could get that report from them on the scrap metal?
Jordan, is that something you think you can do? Yeah, okay. Yeah, thank you for that. All right, any other questions? All right, thank you so much.
You're welcome. May I add, Madam Chair, because I neglected to do so, there is a Senate bill on scrap metal as well. It's Senate Bill 247. Takes a different approach to some of this problem by eliminating the auto dealership exemption to the reporting requirements. There seems to be a case out of Wichita that involved that and that type of situation where a dealer brought in a vehicle and it was stolen. And so there's another approach out there to dealing with the type of problem that folks are looking at. So you may want to consider that as all part of this overall discussion.
And was that heard in Senate Judiciary or not? Hasn't?
Just like this bill, it just came in.
Okay, all right, thank you. Yeah, and so if you would just, when you do send us your testimony, just make sure include whatever you talked about today.
I'll do my best.
Okay, thank you so much. Okay, committee, I will close the hearing on House Bill 2349. And we will go ahead and open the hearing on House Bill 2357 and have Jason Thompson give us a bill brief. Thank you, Jason.
Thank you again, Madam Chair. All right, a little different topic yet still. House Bill 2357, it goes into the housing area. It provides for sealing and expunging certain court records and eviction actions where the underlying rental agreement is governed by the Residential Landlord and Tenant Act. It also requires mediation in those eviction cases unless the court finds mediation would not aid the parties materially. So those are kind of the big pieces of it. The bill brief is fairly long. I go into maybe more detail than you need, but there's a lot of different provisions, especially in Section 1. So I'll try to keep it a little more higher level and let the proponents explain kind of what they're going for, since you have a number of them. Section 1, as I mentioned, is a new section of law. In subsection A, it provides that when you file a petition for eviction under the statutes that govern lawsuits brought to evict a person, and the underlying rental agreement is governed by the Residential Landlord and Tenant Act, the court automatically is going to seal the court file, including the petition, commencing the action, any other pleadings, proof of service, any findings and orders of the court, and all other papers. So if that kind of action is filed, the court will immediately seal it. And then subsection, and it's only then available to the court, the clerk, and the tenant and the lawyers in the matter. Subsection B then talks about how you can, the court shall not unseal the case if it does not result in a judgment, if it's dismissed, or if it results in a judgment in favor of the defendant. So it remains sealed under those circumstances. Subsection C then gets into when the court can unseal a case, particularly if a default judgment or a judgment is entered in favor of the plaintiff. But there are some exceptions to that based on agreement or good cause or best interests of justice. And so those are outlined in subsection C. Subsection D then prohibits consumer reporting agencies, tenant screening agencies, property management companies, landlords, and those standing in positions of property management from collecting or disseminating, causing to be disseminated, or permitting the dissemination of eviction filings or eviction case information that is subject to seal under this section. So those folks are prohibited from sharing that information when they are subject to seal. A violation of that is a violation of the Consumer Protection Act and subject to the penalties of the Consumer Protection Act. And we reference all of those in subsection D. Subsection E then provides for expungement of unsealed or public records of default judgment or judgment in these kinds of residential eviction actions. There's a timing mechanism in there, 2 years after the date of judgment. There's some exceptions for when the judgment hasn't been paid and certain other factors. That's all in subsection E, and I won't get too much into the details there. But there is an expungement provision for these types of eviction actions and getting those records out of the court. Section 2 then goes into a Code of Civil Procedure statute in KSA 60-2617 about sealing or redacting records and makes an exception for Section 1 and the provisions regarding rental agreements governed by the Residential Landlord Tenant Act. So it's essentially just to carve out an exception from that general civil statute. Section 3 then gets into the eviction statutes in KSA 61-38, 04, 06, and 07. That's sections 3, 4, and 5. These statutes apply generally to eviction actions, and in each case, there's a provision created just for eviction actions that involve an underlying agreement that's a Residential Landlord-Tenant Act agreement, right? So a residential case has a special rule under each of these 3 statutes. The first one would be that in an action, in one of those actions involving a residential agreement, the court records and the file will be sealed as provided in Section 1. So that's the first amendment there in Section 3. In Section 4, the amendment is to provide that in those same residential actions, the court shall allow the defendant to appear by two-way electronic audio-video communication versus the personal appearance that's required for other eviction actions, and that the court shall order mediation unless they make a finding that mediation would not aid the parties materially. That provision is not in current eviction law, but it would be for these particular cases. And finally, Section 5 is about trials and continuances, and there's a provision added for these residential actions where the court would allow a continuance, shall allow a continuance if the parties are participating in mediation. Right now, there's very limited circumstances for continuances, and trials are conducted within 14 days after the appearance. So the exception would allow that mediation to occur if it's been ordered. And I would note it takes effect on July 1st if adopted. And I'll try to stand aside unless you have questions for me. That's a very high-level view of a lot of provisions that are going on here.
Okay, committee, what questions do you have for Jason? Representative Vaughn.
Thank you, Madam Chair. Thank you, Jason. Let's see, I think it was Section 1 of the bill when it's talking about the eviction mediation, and it says, unless the court finds that mediation would not aid the parties materially. I'm trying to think of examples of what that could mean in this context. Just from a legal definition, could you expand on that a little bit? How would you maybe interpret that playing out? I mean, mediation seems like it would be beneficial in most scenarios, so I'm just trying to conceptualize that.
Madam Chair, Representative, I'll let the proponents maybe expand on it a little bit more because I think it's based on language I drew from somewhere else or that they suggested. I can't recall which of those, but they'll know. We were very engaged in this drafting process. The provision you're talking about for those following along is actually in one of the amendatory sections. It's on page 4 in line 30 and 31. So generally speaking, in the eviction action, you appear in person and there's a summons and you have to file an answer. And in this case, we're saying in these residential actions, the defendant can appear electronically and the court is required to order mediation unless the court finds that mediation would not aid the parties materially. And you're right, that is not a very specific legal standard. I believe it has a number of meanings, and I can envision circumstances where the court would say mediation is just not viable in this particular case, but it would be a required finding that they have to make, right? So essentially this language makes it the default unless the court makes the alternative finding. So I think that's maybe the point of it, is to suggest that it is most likely helpful in the majority of cases, and you have to make a finding to not send them to mediation, if that helps.
Yeah, no, that does help. Thank you.
Committee, any other questions for Jason? Okay, thank you. This is a little unusual. We're going to have the neutral testimony first. Marissa, are you still here? Yeah, I saw you. Just so you probably have a busy schedule, and so we appreciate you coming over. So we'll go ahead and have you go first, and then we'll do the proponents.
Okay, no problem.
you.
Marisa Bayless, I'm the special counsel to Chief Justice Lukert, so providing neutral testimony today on behalf of the judicial branch. The judicial branch has supported several eviction resolution programs across the state. Most specifically, OJA did initiate the program in the 18th Judicial District in Sedgwick County. With the support of the National Center for State Courts, we did receive a grant, and we also had an ad hoc committee on best practices for eviction proceedings. We also worked with the committee to produce some educational videos about for the public to explain the eviction process and related resources, and those can be found on our website. So I just say that to know that we are definitely proponents of eviction mediation. We just have some concerns about, as the bill is written right now, being able to perform all the things that it does require the court to do. So in new section 1, automatically sealing chapter 61 evictions. So definitely we can seal a case automatically based on the case type. That is possible, and we could do that. We're just a little more worried about then all the provisions and all the things we have to consider after that. So the bill proposes that cases must remain permanently sealed unless there is a judgment in favor of the plaintiff. I will note sometimes judgments don't happen within that eviction case. They sometimes happen in small claims. So we would have to just keep tracking that. There are a number of exceptions to the rule. The defendant can request it, unsealing if the defendant wins. The defendant and plaintiff can jointly agree to unseal. And the court can independently decide to keep the case sealed following a determination of good cause. So some of those we would just be waiting on the parties to come to us to tell us if they want to unseal, but we would still need to be tracking that. And for the good cause, it's includes but isn't limited to a finding that the tenant is a victim of domestic violence, a finding that there is fault by the plaintiff and defendant or any other identified safety, property, or privacy interests. It doesn't necessarily say that we have to weigh that good cause factor in every single eviction case, so we would just like some clarification if that needs, on the outset of a filing, does the judge need to make that, that determination? There are several exceptions to that, so it just need to be made on a case-by-case basis. So we're more worried about the processing of eviction cases and if we can make sure we're doing that efficiently still while still achieving the requirements of this bill. One of our judges did note we would just like some clarification on when it's a victim of a domestic violence. Does that mean it needs to be an actual criminal case conviction? Is just having a temporary or permanent protection order sufficient for that? So just asking for some clarification on that part. For the automatic expungement, so the bill says after the initial determination about unsealing the case is made, courts would need to continue to monitor the case for 2 years, at which point the unsealed case would need to be assessed for an expungement process. So this just flips it from what it does now. So if a person wants to get their case expunged, they have to petition the court. So this would require the court to keep track of that for 2 years, and then make that determination if it cannot be expunged if a monetary judgment is unsatisfied unless the plaintiff and defendant agree to the expungement. So we can tee something up for 2 years down. It's still just going to require us to track it to make sure that there are no reasons for it to remain or to not be expunged. And so it's not necessarily automatic. It just requires us to do that on the outset. There still needs to be a judge to make that determination, to review the case, make sure everything is satisfied, and then move forward. We just worry because their area, and as some of the proponents will probably tell you, we do have a lot of cases. So in calendar year 2023 and 2024 combined, we had around 32,400 eviction cases filed in Kansas. So we would just be required to keep track of all those going forward. And making sure that we are abiding by the unsealing versus sealing provisions in this, and then tracking for automatic expungement as we go down that line. Section 4 of the bill does require mediation, and while we definitely think mediation is a great program to use if it's meant for the parties in that case, right now the current language requires an order of mediation unless the court finds that mediation would not aid the parties materially, as Representative Vaughn mentioned. We do appreciate that there is some leeway to determine if mediation should happen in a case. If the party is just not willing to participate, that might be a reason not to order mediation. Mediation right now, though, is not necessarily just freely available in every county. The majority of counties in Kansas don't have eviction mediations readily available. That's not something the court necessarily pays for. That would be on the onus of the parties involved potentially if there's no local resources to help aid that. So that's just a question on where that funding is going to come if we're required to order mediation. I think there could be some, if the proponents would be willing, some leeway in that to maybe say if available resources are available to try to allow for that. But as of right now, the court is not the one who provides mediation. Local district courts engage in that process and work with their local community resources to be able to do that. And so that's just our concern, and definitely willing to work with the proponents on language and try to have some clarifying things. As it's written right now, we were just worried about being able to do all of this and making sure we're still processing cases efficiently.
Okay, thank you. I do have one question myself.
Yeah.
Do we have any other situations where we do automatic expungements in the state?
Not to my not how this would, not to my knowledge, no. Yeah.
Thank you. Any questions? Representative Carmichael?
Thank you for this opportunity to ask one question, Madam Chair. You mentioned in your testimony, I think it is also referenced in one of the proponents' testimony, that these actions can end up in small claims court as opposed to the limited action docket, I presume. Can you educate me? It's been way too long. What is heard in small claims? What is heard in a limited action or Chapter 61 docket?
So the proponents may be actually better subject matter experts on that. As of right now, I can't tell you exactly what the difference would be, but I can go find that out. Our subject matter from OJ could not testify today, so that's the only.
I'll await the testimony of the proponents. Thank you.
Representative Curtis?
Thank you, Madam Chair. So I think, are you doing a new court it seems like on JCIT, there was a new proposal for a court management system. And I believe that that is the same program that Utah uses, which they actually do an automated expungement process. So I know that in JCIT, when that came up, I asked the question whether that would be something that would be expandable in the system that we've that we're pursuing or have approved. And I believe the answer was yes, that was an out of the box add-on that could be then programmed to fit our needs as well, just like it is done in Utah.
Yeah.
Is that your understanding?
That is my understanding, that other states that have used our case management vendor, they have been able to program certain things. It will cost money. We just don't have that process right now to be able to do that. And I do still think there is still some judicial review, at least, of the order before it goes out. So there's still some judicial review, but I think it helps tee it up a little bit more. What we were worried about is just, it's not so much it's expunged after 2 years, it's expunged after 2 years, but there's different other factors that could prevent that expungement that we were worried that we wouldn't be able to just automatically do that currently.
Okay, all right, thank you.
Thank you.
Okay, we will now call up the proponents. We'll have you all testify and then ask questions if you can stay for questions. I'm going to limit your testimony to 2 to 3 minutes. Just kind of let you know when you're getting to that point. And first, we'll call up Representative Leah Howell from the 82nd District. Welcome to the Judiciary Committee.
Thank you, Chair and Committee. I'm just so short. Okay. So it's so hard to reach the mic. So I'm just going to, you guys have my testimony, but I'm just going to speak a little bit off the cuff. And Chair, I'll just rely on you to let me know my time. So as Representative Howerton and I worked on this bill and conferred with a number of our local electeds and constituents on this issue, and I know it's an issue that many of you are familiar with and have dealt with, there's just a number of things that became really obvious. And one is the current law in Kansas on this issue, that our system is not balanced. There's a lack of due process. It harms a lot of people in our state. And on one hand, property owners need to know that tenants are responsible. But renters also need to have a way to protect themselves from having perhaps inaccurate records that are permanent, that cannot be altered, that cannot be fixed, and cannot be removed. And then having eviction records that are, again, permanent, that end up like a criminal record, is not the American way. This is not how we do things. It's not how we should do things. And this is a bill. Imagine if your medical bill was, first of all, not private, and was there permanently forever, and you didn't have a way to remove that record, have it be private, have a way, even after you made restitution, have it removed from your record. It's not right. It's not justice. So these are the things that come to me. This problem really, in a lot of ways, is due to modern technology, because now we have computers that go through court records and they gather data on all of us. And we know this is true in our everyday life. And so because these records are not sealed, they gather information on these eviction filings, and it doesn't matter how long ago it was, they can use it. It can be used by property managers or property owners to basically blackball you. So this HB 2357 is about balancing this out, making it so that it is fair and equitable for both sides, having a practical solution. I know we're maybe pushing our judicial branch just a little bit with some new technology, and I know it will require some things. Okay, thank you. But by the same token, people will no longer have to come into court and take up the judge's docket. And I think in this day and age, that's something that we can do with some simple software. So that's all I'll say. Thank you so much.
Okay, thank you. And if you'll stay, we'll have questions. Okay, now Christina Guidry from the United Community Services. Welcome to committee.
Thank you, Madam Chair. My name is Christina Guidry. I'm here on behalf of United Community Services and the Kansas Housing Advocacy Network. We do have proponent testimony for House Bill 2357, which encourages eviction mediation and provides for the sealing of eviction filings and expungement of some satisfied eviction judgments. You just heard from the court. My figure was that we had about 15,000 eviction filings each year, but it's actually higher post-pandemic. You heard it's over 16,000, and those have far-reaching effects on our communities, not just for property owners, but also for judicial and law enforcement, and it heightens our demand for public assistance, and it destabilizes workplace and local communities. Beyond that, an eviction filing stays on your record permanently and can make tenants ineligible for housing. That leads to additional homelessness in our state. This bill provides common sense steps to reduce the unintended consequences of evictions and supports healthy communities. So for the mediation piece, you're going to hear from Johnson County, which actually has a really effective mandatory eviction mediation program. What they see is in 90% of cases referred to mediation, the tenant and property owner reach an agreement. 73% of the time, the tenant fulfills that agreement and the case is dismissed. That has realized for them really significant cost savings. Landlords and tenants are in favor of it, and law enforcement alone saved $600,000 in the past year not having to go out and serve those evictions. Beyond that, we have eviction sealing and expungement, and these are essential because really in eviction law, we have flipped our basic tenet that you are innocent until proven guilty to a presumption of ineligibility for housing if you do have any kind of filing. So sealing these evictions until a judgment causes only valid cases to affect tenants. That's about 25% of cases never progress past that initial filing. So it's protecting those 25%. Expunging evictions after 2 years with a satisfied judgment, including any money owed, recognizes the responsible actions of the tenants, and it actually supports the landlord because they know that their tenant has a reason to come back and pay off that judgment. So wrapping up, under this bill, evictions that result in unsatisfied judgments, recent judgments, and repeat judgments will be in the public view. Our property owners will have access to accurate information. At the same time, our tenants will be better able to protect themselves and better able to access housing and remain stably housed, supporting the health of our communities. I am happy to stay for questions.
Okay, thank you. Thank you so much. Dalton Glasscock from the city of Wichita. Is Dalton here? He is not here. Written only. Okay, thank you. Okay, Rabbi Moti Reber, come on up to the podium. Welcome to committee.
Thank you, Madam Chair, members of the committee. I'm Rabbi Moti Reber. I'm the Executive Director of Kansas Interfaith Action. We're a statewide advocacy organization that works on a variety of justice issues, and I'm here in support of HB 2357. So whenever I travel the state, talk to clergy around the state, one of the issues that they bring up is the problem of homelessness. Often churches, faith communities are first responders in a way to homelessness, having food banks or being asked for support. So it's an issue I hear about a lot. I know that legislators hear about this issue a lot too. So about a year ago, a little bit more than a year ago, we joined the Kansas Housing Advocacy Network, which has a comprehensive platform around the twin issues of affordable housing and homelessness, which includes preventing people from becoming homeless, helping to stabilize them in their housing, and also to help people who are homeless to get additional housing. And I think this bill addresses the last two of those. And I'll just, I asked we're partners with the ELCA Lutheran Church, and I asked their national office, and they have a statement, a social statement called Sufficient Sustainable Livelihood for All. Access to three bullet points: access to safe, affordable housing as a basic human right, support for policies that reduce barriers to housing access, and calls for congregations to advocate for those experiencing housing insecurity. Evictions create instability for everyone involved, for the families, for the person, for the families, for their communities, for schooling, for the kids. It's very disruptive. Certainly, evictions can also keep people from getting housing in the future, and also can keep people from getting employment in some cases, because employers check that records too. Johnson County said that 29% of homeless families have been unable to rent an apartment due to previous evictions. This becomes a scarlet E on their records. It's called a scarlet E because it stays on their records permanently, as it's been described. 17 states have, and the District of Columbia have actions like this. And it's also racially disproportionate because Black and Hispanic families are much more impacted than by eviction filings and eviction judgments nationwide. And I'll just say that you've heard about the tenets of the bill. I'm not going to go into that too much. It's in my written testimony. But I'm just going to say that evictions can be the terrible result of a cavalcade of issues. There could be a lot going on. It could be job loss, or it could be a health crisis that causes financial disaster. We think that could be temporary in nature, but have permanent repercussions for the people involved. So we're asking for this body, for the legislature, to give these people a second chance with full restitution, sealing the records so that it does not become the scarlet E on their record permanently. So we urge this committee to pass 2357, and I will stand for questions at the appropriate time. Thank you.
Okay, thank you. Perfect timing. Now we'll have Megan Foreman from Johnson County Government via WebEx. Megan, are you with us?
I am. Can you hear me?
Okay, we sure can. Thank you.
Wonderful.
You have 2 to 3 minutes, please.
Terrific. Thank you.
Uh-huh.
My name is Megan Foreman. I'm the housing coordinator with Johnson County Government, and we are here as proponents of House Bill 2357. Beginning in September of 2023, the county partnered with the 10th Judicial District Court to support the eviction mediation pilot program. And my comments today will mostly focus on the data and feedback collected in that program. The bottom line is that it's been very successful in resolving the issues surrounding eviction, including making sure that landlords are fairly compensated and regain control of their properties, while also maintaining the tenants' ability to have stable housing in the future. These also save public safety dollars, as you heard from Christina Goodry. So over 90% of tenants and landlords are able to reach an agreement in mediation, and 70% of the agreements, or 73% of the mediated agreements, are successful, meaning that there was not an eviction judgment filed in the case. In situations where those mediations were not successful, the judge typically issued a pocket eviction judgment, usually in favor of the landlord, without any of the parties needing to come back to court. The property owners have been very positive about this program. Almost 74% of landlords completing our follow-up surveys said that they agreed or strongly agreed that eviction mediation was beneficial. This is often the first chance that the parties have to speak face to face. So the written mediation agreements give landlords more certainty on when the tenant will move out. It also, in the cases, about a third of cases, the tenant remains in the unit, and the landlords say that this signed agreement usually results in actual payments as opposed to a promise on a phone call or an email that's a little bit less formal. The mediation process reduces the likelihood of tenants damaging the units and abandoning their property, both of which are timely and time-consuming and costly for landlords. Christina mentioned the public safety implications, but just for a little bit of perspective, the folks in the Johnson County Sheriff's Office are responsible for serving the formal writs of eviction, so essentially the get out notice. These are time-consuming, expensive, emotional, and dangerous for the deputies. We dispatch 3 deputies on these calls, and they can take about 9 hours. And it's over $500 per case that these deputies are serving. So all of that is at the taxpayer's expense. Finally, the tenants are going to benefit from the portions of this bill. Our program found that 7 in 10 people participating in eviction mediation had incomes at or below 50% of the area median income. So for a household of 1 person, that's about $36,000 a year. These families are almost certainly housing cost burden, meaning that they're paying more than 30% of their income for housing. 2/3 are women, and 57% have at least 1 child in their household. Most tenants say that they are behind on rent and that the situation came from a job loss or an employment interruption or an unexpected expense like a medical bill or a car repair. When these folks are housing cost burden, there's very little money left over to cover emergencies like this. And it's
so
worth
Megan,
noting.
you have about 10 seconds. Can you wrap it up a little bit?
Sure, certainly.
Okay.
I think, as other speakers have mentioned, the permanency of these records can be really challenging for families. So thanks for the opportunity to speak in favor today.
Thank you. Sorry for the short time. We're trying to fit a lot in. So lots of folks today. Thank you. And if you'll just, someone may have a question for you if you don't mind hanging on. Okay, and then last in person, Mike Hoheisel from the City of Wichita, council member. Welcome to committee. Especially if family members are watching.
I feel
or
a
not.
draft
Yeah.
or something somewhere in the back here. I don't know what that's about. I'm going to deviate from my written statement. We're all politicians, a little long-winded, so I'll try and keep it condensed to the meat and potatoes, which is how this impacts the people on the ground in the real world, which I think is at the center of a lot of our hearts of service. 2 years ago, a pretty infamous case of neglect and illegal activity took place in my district. Residents of Emory Garden, an apartment complex that is notorious for code violations, reached out to Councilmember Johnson and myself with concerns of black mold, bed bugs, roaches, and many other code violations. I urge you to look it up. I sent a link in with one of the reports, but it's pretty bad. In speaking with many of the residents about their situation, we learned that they had made a deal with the current management company that they didn't have to pay rent until either they moved out or the infestation problem was taken care of. The reports made the news, and not long after, the property manager came to town to assess the situation. What he in fact ended up doing was evicting everyone who had withheld their rent and reported violations to the press or to City Hall MABCD. This was, I believe, in direct violation of the landlord eviction laws passed on the state level, although there was no enforcement arm. We have since passed a landlord retaliatory ordinance on the city level to help stop this from happening again, much like what we have up in Johnson County. But since the rent had been missed, even though it was under an agreement with the management company, the residents were still evicted, and this will be on their records permanently. It's easy to see the injustice under this situation. It takes a closer look to see just how it has impacted these residents, victims of predatory landlords. Earlier this year, a grandmother reached out to me because she was trying to flee an abusive relationship. But since she was one of the residents evicted from Emory Gardens, she was not eligible for vouchers to help women escape situations like this. This law may not help everyone, and there may still be a gap in how long an unfair eviction will stay on the record, but it is a good step towards addressing retaliatory evictions. I thank the committee for their work, and I am here to help any way I can.
Okay, thank you. Okay, committee, what questions might you have for the proponents? Representative Barrett, if you would just say who you want to ask the question to and.
Thank you, Madam Chair. I guess this question could probably be answered by Megan from Johnson County. Hi, Megan, can you hear me?
Yes, I can.
Awesome. So, I think this, I mean, it sounds like a great bill. My concern, I guess, was brought up by the Judiciary, the judicial branch, I'm sorry, which mentioned when it comes to mediation, a lot of small counties don't have that service, is what it sounds like, based on their testimony. In Johnson County, are you guys using a private company? Do you have hired mediation? How are you, obviously you're a lot bigger, how are you approaching that issue?
Sure, the district court is handling finding those mediators and scheduling them, although I will say that there's probably a lot of promise for doing this as a web-based sort of activity, just like we're doing now. I know that there are lots of different groups of folks who've come together to be certified mediators, and they kind of come from a bunch of different walks of life. But, you know, it's in terms of a pretty cost-effective policy. I think they get paid $250 a day, but they're hearing any cases that are sent to mediation on the docket. So you don't always have a firm number on how many you're hearing. But the county has been putting up the money for those mediators, but really, given the cost savings on the other end, it's a pretty good bargain. So I guess my only thought to that would be that, yes, it's nice that they can be in person in the larger communities that have, you know, a stash of mediators on hand. But if not, I think probably a lot could be done online.
Representative Osman.
Thank you, Madam Chairwoman. I have a question for Ms. Guidry. Hi, thank you for your testimony. I wanted to find out if you might be able to help me understand, typically in a landlord background check, what do they look for? How do they find it? And then is there any way that one can find the information that has previously been sealed by a court order?
Okay, so if you look at my testimony, am I on?
Turn on the mic.
I just wasn't close enough, sorry. If you look at my testimony, I actually have a link to an article that like kind of will take you through this. It's really actually interesting, but they will pull your credit history. They look at your, they check all court filings for any kind of eviction indicator or any kind of judgment. But there's like 6 different parts of any kind of tenant screening report. The way that we have the way that this bill is currently written, there is the enforcement piece where if they do pick up a sealed case, then there is a private right to action under the Consumer Protection Act. I believe I'd defer to Jason on that, but that would be the protective factor so that they couldn't pick up these sealed cases. They would only be able to pick up unsealed cases.
Representative Bohai.
Thank you. I don't know. My question is regarding automatic expungement. So whoever wants to take that. It can be neutral or it can be a proponent.
Why don't you start asking the question? And
Well,
maybe
my question is, with automatic expungement, expungement's great for expungement. With automatic expungement, is it putting undue stress on the courts, and or what is the current process? Is there currently a petition, and why wouldn't we just go forward with, after 2 years, petitioning for expungement?
Yeah, Marissa, maybe you're the best one for that one.
Marisa Bayless with the judicial branch. So yes, the current process would just be an individual petitioning the court for expungement. I'm not for sure what the time frame is currently, but if it's 2 years, then they would, after 2 years, and if they met all the other satisfactory requirements, they would expunge. So if we do automatic expungement, it's just the court is going to have to keep track of where that case goes. If there's another eviction that happens with that individual, making sure we find that if it's not within the same county or if it's within a different county. And then making sure we tee that up at the correct time and if everything follows. So we're just changing that. That's what automated expungement does. Right now, we don't have to track those cases. They just come to us when an individual meets certain requirements.
Representative Howell, did you want to add a quick note to that?
I just wanted to add
Go ahead and
my,
introduce yourself. If
yes, thank you, Representative Howell. And I just want to add my thoughts since as part of the writer of this bill or the requester of this bill, that is, my goal is to keep everyone working in the state and not having to take off work to come to the court or to pay fines, which every time you do anything in court, you usually have to pay some kind of fine. And our courts are swamped. And so to me, if there's a way to automate it, make it so that our judges or anybody else is not having to work with the public, and then that is a savings to the taxpayers, obviously, and keeping our families working so that they can pay off the bills that they already owe is a major plus. So that was my logic behind it.
Thank you. Representative Carmichael.
Thank you, Madam Chair. In order to comply with the chair's one question rule, I will not follow up on my question regarding small claims actions versus limited action jurisdiction. Instead, I would like to ask of Ms. Ashi Gidry a question that follows up on what some of my colleagues have asked, and that is at page 4, line 30 of the bill. As we've heard, the bill provides that court shall order mediation unless the court finds that mediation would not aid the parties materially. In those circumstances where unfortunately we don't have mediators available in counties, which hopefully we'll be able to fix, my presumption is it wouldn't aid the parties materially, and hence a judge wouldn't order mediation if it can't be accomplished. But if I'm wrong or whatever, help me with that one.
That seems a reasonable reading to me.
Thank you for the privilege of asking the question, Madam Chair.
Representative Bourgeon.
Thank you, Madam Chair. Maybe a comment. I'm a little bit surprised that we're not hearing from someone that's representing the property owners, because I'd be interested in their perspective on the bill. We did have one proponent, Megan Foreman. Could she answer a question?
Mm-hmm.
I'm here.
Thank you for your testimony. You had alluded to, or I think you made a statement that of the property owners that you work with, 74% of the property owners support the process. Could you elaborate a little bit on that, and like how many folks were part of that survey?
Sure. I don't actually have the baseline number of the total that we had in this survey. It's certainly not anywhere near the total number of evictions that you're seeing. Our mediation program, the folks in it go through several different processes. And so once you get down to a much smaller number, about 400 cases or so was what we mediated over the course of a year in Johnson County. So that 74% does not include all 400 of those cases. But those folks that did respond said that they agreed or strongly agreed that it was beneficial. And, you know, there were several points in my testimony about why, but I do think that it gives a little bit more of an opportunity to speak face to face with the tenants and kind of come to an agreement that everyone can live with. Most typically, the landlords get paid what they're owed in back rent and take back possession of their unit. It just it tends to mediate some of the problems that they also see, like abandoned property or damage to the units, or needing the sheriff to come out and evict somebody. It tends to ameliorate those challenges that we see.
Committee, one more question. Representative Lewis.
Yeah, thank you, Madam Chair. I'll talk to the lady that's on the WebEx. Thank you for your testimony. I'm generally in favor of the bill, but there is one concern I have. I mean, let's say you have really a deadbeat tenant, and they're trying to play the system. You know, the mediation provision, and I generally like mediation, but it's going to, it could very well delay the eviction process. The court orders mediation, and then this bill provides that they can extend the date for a trial if the parties continue mediation. So instead of a 14-day period between the time for the summons to be answered and the trial, you could, you know, indefinite period. How do you respond to that concern?
Representative, I actually think Ms. Guidry would be a better person to answer this. She's a little bit more familiar with the bill language itself. I'll say that in our mediation program, it's still very quick. Sometimes the parties can agree to, you know, a little bit of extra time for that tenant to perhaps pay what they owe or to split it into payments. But we're not seeing these things drag on for months and months and months. And that is something also that in mediation, a landlord could ask for. If it is a problem tenant, you know, that they want this resolved within, you know, a certain number of days. And then that's something that the mediator can take into consideration.
Right. I'll
Go ahead, Ms. Guidry, if you'd like to add something.
Sure. Kansas's eviction process is actually one of the fastest in the country. So from the time you post the 3-day notice to the answer hearing could be 3 to 5 days. And then from the answer hearing to the actual trial, or in Johnson County, the mediation that's ordered is 8 days. So it's very truncated. I would not imagine that judges would extend for a long duration for mediation. I mean, it doesn't say that. But in Johnson County, we don't even use a continuance. And I would imagine that larger counties would be in a similar situation.
Thank you.
And using WebEx, you know, would make it very easy, relatively speaking.
Does this bill have a time limit on the mediation, Jason, or? No, okay, all right, thank you. Okay, thank you, everyone. We appreciate it. There's also written proponent testimony from Marilyn Harp, Dustin Hare, Brandon Johnson, Jonathan Smith, Matthew Kleinman, Casey Johnson, and Nathan Madden. So committee, please take a look at those. Okay, I will close the hearing on House Bill 2357. We're now going to work 2 bills. Committee, we're going to start with House Bill 2155. We're going to do the procedure just a little bit different because it seems that sometimes we move a bill and then we make an amendment and we have to redo the motion because it's not the same motion. So we're going to try something a little different this time. We're just going to talk about the bill first, 2155. I'll have Jason give us a reminder of what it's about. We'll see what discussion we have, see if there's any amendments, and then we'll do the motion. We're going to try it that way this time. So Jason, if you would give us a reminder of 2155.
Thank you, Madam Chair. House Bill 2155 is the bill about sheriffs and providing that their liability on their bond under KSA 19-811 is only for official acts and not just acts.
Okay, committee, what discussion do we have about this bill? Do we have any amendments? Do we have anyone that has anything about that they'd like to discuss about this bill? Sorry, Representative Carmichael.
Thank you, Madam Chair. Some of you may recall the discussion that I had with Sheriff Easter about the impact of the sheriff's bond as opposed to a county's general liability insurance, for example. And subsequent to the hearing, I have heard from folks who have problems with the bill and think that there are difficulties involving sheriff's bond versus general liability, confusing the issues and perhaps making the current situation worse than it is. But sadly, because of our hurried schedule here in the legislature and the way agendas come out, they weren't able to make it. So I'm not going to make their arguments for them because they weren't here. But I hope they'll bring those arguments to senators if we should pass this legislation. But until I'm satisfied that this is a good idea, which I'm not, I'm going to have to be a no today. Thank you.
Representative, did you say who it was? Sorry, who that was that had concerns? I missed that.
I did not.
Okay, thank you. Okay, any other discussion, committee? Representative Barrett.
Thank you, Madam Chair. I would just say from the perspective of someone who's worked in a jail, before I turned 21, I worked in a small county jail. You know, they have very good policies outlined to protect themselves. And I think this bill is a good idea because sometimes you'll have bad actors get hired on. They pass the background check, they pass the process, and they do acts that are not official in nature and they're criminal in nature, and they face those criminal penalties. I just think as long as the sheriff's office has policies protecting them from that, as long as they're following their guidelines and it's not within their official act purview, I think it's a good bill. Thank you.
Thank you. Any other comments? Representative Williams.
Thank you, Madam Chair. I move that we pass House Bill 2155 favorably for passage.
We have a second. Representative Bourgeon, seconds. Okay, any other discussion? I will go ahead and do discussion again. Okay, seeing none. Representative, would you like to close?
I close.
Thank you. Okay, committee, you have heard the bill to pass, motion to pass House Bill 2155 favorably for passage. All those in favor say aye. Aye. Opposed, no. The ayes have it. We will pass House Bill 2155 out for passage, favorably for passage. Representative Carmichael would like his no vote recorded. Thank you. Would anyone else like their vote recorded? Okay, thank you. Okay, I will now open up discussion on House Bill 2062. And Jason, if you could give us a brief on that one. Thank you.
Madam Chair and committee, this is the bill relating to orders of child support that provides for child support orders for unborn children from the date of conception.
Okay, let's discuss this bill. Committee, what questions, what amendments do people have? Representative Osmond.
Yes, thank you, Madam Chairwoman. I have an amendment.
Okay, Jason, you have that you can pass out for us? Okay. Would you like to explain your amendment?
Yes, while it's being passed out. The proponents actually presented some interesting arguments as far as the fundamental nature of this bill, which is about child support payments for the mother, for the child. And it's, you know, the part that they brought up was that what's the problem with the law? There is an inconsistency among judges to actually rule the same way. And so that needs to be clarified so that we actually have that protection in the law and that we actually have child support payments being utilized in this way. So my amendment basically just focuses on that to make sure that there's the, as I said in line 24, part 10, the direct medical and pregnancy-related expenses of the mother. So that is what the bill is about. That seems to be what the proponents as well were discussing. And so I just wanted to highlight that. It is the medical and pregnancy-related expenses of the mother that I think is a good thing for us to be clarifying in law. So that's my amendment.
Would you like to move your amendment?
Yes, Madam Chairwoman, I'd like to move my amendment.
Do we have a second? Representative Curtis seconds the amendment. Okay, committee, what questions do you have, the maker of the amendment, or discussion? Representative Bohai.
Thank you, Madam Chair. Representative nope. No, but do I say that or did I just say where he's from?
In committee, you can say. Yeah.
Sorry, thanks. Sorry. Do we have a definition of direct medical or pregnancy-related expenses? Is there a definition of that?
That might be a question. Thank you for your question. That might be a question better suited for the revisor. However, I mean, I think this comes directly from the original language of the bill itself. So I don't know if that is defined specifically in the bill, but yeah.
Jason, do you, it's not, and because I'm looking at page 1, line 24, and it's in italics, so I'm thinking that's added language that was added in the original bill. Is that?
Correct, Madam Chair. The provision in line 24 is new language, as is the rest of the language below it that is stricken. That's, so part of the new language is retained and the rest of it is stricken.
Okay, committee, other questions? Representative Carmichael.
Yes, a question of the revisor, just to make sure that I understand. At page 1, line 24, the clause, the direct medical and pregnancy-related expenses of the mother, that is all from the original bill, and where this amendment impacts the original bill in that clause is that it strikes the language, if the child is an unborn child. Am I reading that correctly?
Madam Chair, Representative, yes, it strikes that phrase in line 25 and the remainder of the bill.
Then to address on the merits, if I might.
Yes, go ahead.
Thank you. You know, actually, this is a pretty good idea no matter where you're at on the abortion debate, because the bill as phrased would only provide for payment of direct medical and pregnancy-related expenses of a parent if the child was an unborn child. And I think we want to make sure that those bills are paid, whether we have whether it's during the course of a pregnancy or even if hopefully there's a born child, we still want those pregnancy expenses covered. So whether you're pro-life or pro-choice, I think you'd probably want to strike that clause at page 1, line 25, and that's part of what this amendment does. Thank you.
Representative Barrett and then Vaughn.
Thank you for just for the bring of the amendment. So there's a lot of other definitions I see that are also being taken out, like for example, page 2, line 10, going down and then also page 2, line 23, where it's giving more clarification. Like for example, on that line 23, regardless of the type of custodial arrangement ordered by the court. I mean, providing all this clarification, it seems to, you know, for interpretation later down the road, for the courts, for law enforcement, whoever's enforcing this, it seems it would help if these definitions are in there. I'm just curious your reasoning for removing everything.
Thank you. Thank you very much for your question. The reason that I think that we needed to highlight just this and to remove the rest of it is because the question of unborn child or child doesn't need to be conflated with regards to what we're talking about here, which is child support payments. And what we're talking about is pregnancy-related expenses of the mother. And so those don't need to necessarily be defined in terms of what is a child or isn't a child. It's a question of, are they pregnant? Do they have pregnancy-related expenses? That's the focus, I think, of my amendment.
Representative Vaughn.
Thank you, Madam Chair. And just to that last point, if I may, possibly for the revisor, I think in those boxes also that are those lines that are being referred to, it indicates it maintains the current law versus totally eliminating those definitions. So I think maybe that was just a revisor choice in how the amendment was, how it looks. If I don't know if I'm making sense, but yeah, I think that part maintains current law if I'm understanding correctly.
Yep, Jason.
So, Madam Chair and Representative, so in order to show removing something from the bill, I have to strike it. So that's the choice there. And by maintaining current law, I mean anything in regular font, that's current law. That remains if we don't amend it, right? If you don't amend it in a bill, it stays the law. The parts that that you would lose would be anything in italics, right? So, for example, in section 2, the amendment in italics in line 14, parent and child relationship, and part of that. And then in line 17 and 18, that was going to be new to this bill. That would be removed. So anything in regular font, current law, not changed. What you lose is anything in italics that the bill was attempting to add. So hopefully that helps.
Madam Chair, may I?
Yep.
Thank you. So just to speak to the merits of the amendment, I thought a lot about this bill because I do appreciate the underlying motivation, which is to ensure that mothers are duly compensated for pregnancy-related costs in the medical appointments that they have. And I think where I was going back and forth in our committee discussion of the bill is that already covered in current law? And so I did reach out to a family law attorney who serves on the Judicial Council to get advice from a legal perspective of how the law is currently interpreted. And it was his opinion, based on the cases that he's worked, that those costs are already currently considered in child support cases and determinations. But by putting it in the statute and clearly saying that the legislature wants direct medical and pregnancy-related expenses of the mother to be considered, I think it further clarifies that without adding all of these other elements that I think potentially add complications to the enforcement of this bill that we talked about in the hearing as well. Things like, the parental determination and and some of those other things that I think get away from the original purpose, which is to make sure that all of these expenses are fully covered. And I hadn't considered this as an amendment, but I think this really encapsulates my thoughts around this, and I'm supportive of it. So, thank you.
Representative Lewis.
Thank you, Madam Chair. I guess this is more in the nature of a question and maybe a concern. So section 3, as I understand the amendment, if I'm reading properly, it takes out section 3, which provides for support for education of the minor child. Am I accurate about that? Is that what the amendment does?
That's page 2, line 19.
Yeah, starting 19, section 3. Exactly. I guess that's a revisor question first.
That might be a revisor question. I believe that it just maintains current law, which would still allow for that.
That's what I don't understand from looking at this, but maybe you can explain that.
Madam Chair, Representative, I'll try one more time. I know this is difficult because what you're presented is an amendment to it, which is in italics, and I have to remove the whole section so that it's not amended in any way by your action. So all of the language on page 2 except one, that, which is in italics, I think, is current law. The amendment that was proposed to that section is at the very end of it, line 13 through 16 on page 3. So everything else is there that's in section 3 is current law and would be unchanged if you removed it from the bill. What would be lost is the as used in Article 30 phrasing there at the end of that section.
I see. All right, thank you for that.
Any other questions or Representative Esau?
As I was reading that, does that mean that we've taken out the definition of unborn child, or did I blink and miss that when taking that out?
That is correct. It would take out the definition of unborn child. And I will say, one of my concerns as well, which I don't think I brought up in the hearing, but there is a real concern about guardian ad litem's. Now, there is a resource issue in terms of who gets assigned to one, but under Kansas law, you can have a GAL for divorce proceedings and child support payments. And what I worry is we're already stretched thin as it is. It is difficult. And if you start to put in definitions of an unborn child into this, there is a real concern that perhaps a GAL will actually be assigned to an unborn child, which would complicate matters significantly in terms of how even these child support payments are being processed and the length of time that it would take to seek reimbursement for child support payments. And so just for government efficiency, I wanted to make sure that this wasn't included in the law.
Committee, any other questions? I was just curious about on page 1, line 25, where you took out if the child is an unborn child, and why did you take that phrase out?
Thank you, Madam Chairwoman. The reason why is because we also took out the definition of unborn child. And so it's all covered itself under the medical and pregnancy-related expenses of the mother. So all of that is being covered under pregnancy-related expenses without necessarily worrying fundamentally about the child and how support is structured for that, whether it be a child or an unborn child. It's all covered under pregnancy-related expenses of the mother.
And if I might ask, so in the title, the part that's taken out is child support for unborn children from the date of conception. And so my question says, so it just says providing for consideration of the direct medical and pregnancy related expenses of the mother. Is that correct? I'm just reading what the kind of what the new title would be.
Yes, that is correct. Because there's no definition in there, we're just dealing with the child support payments. So it's not referring to anything that's no longer in the bill.
Okay. Yes. Okay, committee, yep, so we have a motion and we have a second. Is there any other discussion? I would say I think what is in this bill at the moment is the intention of the maker of the bill, and I would agree with that. So I will be voting against the amendment, just so the committee understands. But all right, yes, yes, please.
Is it going to be the policy of the chair to vote on bills even if there's not a tie, so we understand where we're going? Because that's the usual practice.
I appreciate that question. Thank you. No, great clarification. I will not usually be voting unless there's a tie. And there's an odd number on the committee. So, yep, thank you for that clarification. I appreciate that. I guess I should have rephrased that. Okay, would you like to close on your amendment?
Thank you, Madam Chairwoman. Yes, I close and move my amendment.
Hey, committee, you've heard the amendment from Representative Osman to House Bill 2062. All those in favor say aye.
Aye.
All those opposed, no. It's the decision of the chair? Okay, so we will be raising hands. Raise your right hand, please. All those in favor, raise your right hand. And staff, y'all are making sure you count. Okay, thank you. All those opposed, raise your right hand, please. Okay, thank you. All right, the amendment fails.
Madam Chair, I ask that my affirmative vote be recorded in the minutes of this meeting, please.
Absolutely.
Thank you.
Is there anyone else that would like their vote recorded? Representative Vaughn and Representative Martinez, Representative Osman and Representative Curtis. They would all like to have their no, or their, excuse me, their yes vote recorded. Representative Curtis, Osman, Vaughn, Carmichael, and Martinez. Anyone else like your vote recorded? Okay, thank you. Okay, what other discussion do we have on House Bill 2062? Any other amendments? Representative Carmichael.
I'm sorry, I was for purposes of discussion, not an amendment.
Oh, either way,
Discussion.
either way.
Thank you.
Yep.
When I first heard about this legislation, I think it was sometime last spring, maybe last summer. As I recall, 2 representatives from Wichita were supporting this legislation, at least 2 that I knew of at the time. And ironically, it was the same day as an appearance on the television show that comes out of Wichita about public affairs. And at the time, I certainly said, you know, this makes sense. We want to take care of pregnancies. We want women who are pregnant to have the best access to the resources that are necessary for a healthy pregnancy and a healthy life going forward for a child. And, you know, that all made real sense. Then some of my friends who practice in this area of the law told me, well, this already is the law. This is already what's taking place. This is the Supreme Court's rule that so-called deadbeat dads and even dads who are responsible fathers get to pay their part of the expenses of a pregnancy as a part of the general obligation to pay child support. So then we have to ask, so what is it the bill does that is different than the existing law? And I think we know what the difference is. It has to do with definitions of personhood or unborn child as a child. And I understand there's a lot of people in this legislature that want to legislate frequently on those sorts of matters. And here we have the opportunity again. I was prepared to support this bill with the Osmond Amendment, even though I wasn't necessarily persuaded that it was truly necessary. I thought it did little harm and probably helped make dads aware of the fact that they're going to pay the bill. But now, with us confusing this with an abortion debate, particularly in view of what not only the overwhelming number of voters in Kansas said about the right to bodily autonomy and the right of a woman to make her own decisions concerning her pregnancy, but in my district in particular, those numbers were exceedingly high, somewhere in the area of 75%. So I can't go along with this bill because I think it's contrary to the announced desires not only of the majority of Kansans, but certainly the majority of people in my district. So I'll be voting no. Thank you.
Thank you. Any other discussion on the bill? Representative Williams.
Thank you, Madam Chair. I move that we pass House Bill 2062 favorably for passage.
Do we have a second? Representative Ward seconds. Any other discussion? A new way of doing it. Okay, thank you. Would you like to close on your amendment?
I close.
Okay, committee, you have heard the motion to pass House Bill 2063 favorably for passage. Oh, sorry, 62 favorably for passage. All those in favor say aye. Aye. Opposed, no? No. The chair believes that the ayes have it. And so House Bill 2062 will be passed. We will record Representative Carmichael's no vote.
Thank you. Thank you for pausing, ma'am. I appreciate your courtesy.
Representative Martinez, no vote. Representative Vaughn, no. And Representative Curtis, no vote. Any other vote record? Okay, thank you. Okay, thank you. Good work today, committee. I really appreciate it. I'm sorry that we have to abbreviate things. I think you have the agenda for tomorrow. We'll just press on with our mini bills and get going, and appreciate your work. Thank you. We're adjourned.